Good afternoon, everyone. Welcome. First of all, I'd like to apologize for the delay. Obviously, something that we could not help. There's been numerous times as a lawyer where I kind of wish that there was a fire alarm right before I got up to argue. Unfortunately, that never happened, and I guess we're going to go ahead anyways today. I'm going to read some procedural things because this is a little bit different than what most of you are accustomed to. Today we will hear oral arguments in two proceedings currently pending here at the board. In an effort to move things along, the board members will not be making opening remarks this morning, but I wanted to cover a few procedural matters before we begin. We have asked each party to make a short statement of their arguments, but counsel should be prepared to answer questions from the board at any time during your allotted time. I assure you that we have read all of your pleadings, and there is no reason to repeat every argument. Just a general thing, because we try to frame this more like a Court of Appeals type argument, as opposed to how we've held hearings in the past, to give you a better idea of the way things we're trying to make them go. Speakers, please note that the timing lights are in front of me. You will see a yellow light when you have 1 minute remaining, and a red light when your time has expired. Please keep to the time you have been allotted. When you see the red light, please finish your thought and take a seat. Additionally, just a reminder to everyone, please turn off your cell phones. The first oral argument we will hear is in STB docket number 42104, Entergy Arkansas, Inc. and Entergy Services, Inc. versus Union Pacific Railroad Company and Missouri and Northern Arkansas Railroad Company, Inc. Counsel for Missouri Northern Arkansas Railroad, you have been allotted 30 minutes. Please step up to the podium, introduce yourself, indicate if you have reserved any time for rebuttal, and then begin. Thank you.
Good afternoon. Chairman Elliott, Vice Chairman Nottingham, Commissioner Mulvey. My name is Lou Gittimer, counsel for the Missouri Northern Arkansas Railroad Company, Inc. With me today are Scott Williams, the Vice President and General Counsel, and Thomas Gibson, the General Manager of the M&A Railroad. I've reserved 10 minutes for rebuttal. The M&A is a Class 3 railroad, revenues of about $28 million last year. It operates 580 miles in Missouri, mainly Missouri and Arkansas, and leases about 380 of those miles from the Union Pacific. We've moved to dismiss this proceeding on three grounds. One, there is a necessary defendant that has not been named in the amended complaint filed by Entergy Corporation, or the Entergy entities. In addition, there's a contract between the Union Pacific and Entergy for the movement of a vast majority, if not all, of the coal that the Entergy Independence plant in Arkansas uses. Finally, there is an existing through route, even though it is for single car movements, and we feel that's appropriate because the complaint does not specify that Entergy is talking about unit trains. In fact, it doesn't specify very much about the movements that it's seeking to make. It's talking about moving coal to Independence over the Missouri Northern Arkansas using a through route. The complaint does not identify the other party to the through route. In our motion to make more definite, we asked them to identify the party to the through route, and we also asked for some information about the through route, including such points as the origin of the movement and the point of interchange, neither of which have been identified. I'll be glad to answer your questions at any point in time during this presentation. Although the board gave Entergy a roadmap for filing the amended complaint when it denied the initial complaint in June of this year, that did not give Entergy leave to file an incomplete amended complaint with the board. And that is the issue that M&A is raising today and raised in our papers, that, again, the NSF was not identified as a defendant, that there's a contract between UP and Entergy, and that there is a through route over which Entergy could move traffic to the Independence plant between the BNSF and Missouri Northern Arkansas, or any of the other railroads that interchange with the Missouri Northern Arkansas. The through route has been sought previously informally by Entergy. They've asked Missouri Northern Arkansas quota rate to open a route, and as provided by the board's rules, we've in turn asked them to provide additional information. That's the same thing that's going on in this proceeding. However, they've asked the board to prescribe a through route. In turn, we filed the motion to dismiss, motion to make more definite, seeking more information. Again, that information has not been provided. It's very difficult to open a route to quote a rate when you don't have necessary information concerning the movement that the shipper is seeking a rate or a route for. This is the first proceeding before the board under the rules at section 1144. Those rules require a comparative analysis between the current move and the new through route that the moving party, that the complaining party is seeking. Here it's very difficult to make a comparison. We know the factors involved in the current route from the Powder River Basin over the Union Pacific to the Missouri Northern Arkansas, and then for final delivery to the Entergy Independence plant. What do we know from the amended complaint about the new through route? We know that the through route will be over the Missouri Northern Arkansas. We don't know the origin points. We don't know the railroad that will provide the through movement with the Missouri Northern Arkansas. We don't know where the interchange should be. Those are necessary elements in proving the case, and they should be necessary elements in the amended complaint.
Hasn't Entergy indicated that it accepts that it would probably be BNSF, that BNSF would be the connecting railroad, and that it was willing to attest that BNSF would be the connecting railroad?
I don't recall the word attest in any of their papers. I believe what they said is they would amend the complaint with leave of the board. The board's rules indicate that you can amend your complaint at any time with leave, and if they truly wanted to amend the complaint, they would have filed a motion with the board for leave to amend, and they would have amended it prior to this time. This matter was filed back in August with our answer 20 days after the amended complaint was filed. As far as would they definitely use BNSF, I don't think there is a commitment in their papers, number one, to definitely use BNSF as the connecting carrier. And number two, there is no commitment anywhere in any of their papers to make use of this route at all. This may be just a theoretical argument by Entergy, maybe a realistic argument by Entergy, but Missouri Northern Arkansas is very concerned that if it is ordered by the board to open a through route, it would incur substantial costs in order to prepare the route to handle the traffic generated by Entergy. But again, we don't know what traffic Entergy is talking about. We don't know if we're talking about one unit train over a 1 year period. We don't know if we're talking about 2 unit trains per day. We don't know if we're talking about trains moving at 10 miles an hour. We don't know if we're talking about trains moving at 45 miles an hour. And as you well know, there's a substantial difference between the costs involved in preparing to move trains within those different criteria. And those are just endpoints. Those don't include all of the potential iterations within.
You said unit trains, but did you quote a unit train rate, or did you quote a single car rate?
There is a single car rate quoted on the current through route.
Did you suggest that obviously it would be a unit train for movement of coal, be unlikely to move in single car loads. It'd be a unit train movement. So why didn't you quote a unit train rate rather than a single car rate in the tariff?
As I explained before, we have been discussing this matter with Entergy over a number of years. A number of times Entergy has come to MNNA, requested a rate quote. In response, as provided by the board's rules, MNA has then gone back to Entergy and asked Entergy, please provide us with the following information. Each time that we have requested that information from Entergy, Entergy has not provided that information. That is the same situation that exists with this case. As you know, Entergy began this proceeding by sending a letter to Missouri Northern Arkansas requesting a through route and a rate quote. In response, Missouri Northern Arkansas sent a letter back saying, please provide us the following information. The response we received from Entergy did not provide all of the information necessary for the through route and the rate quote.
Mr. Gittimer, could you describe this through route that you've referenced a few times? Would it go along a specific alignment, and where would it? What would be the beginning and end points?
Vice Chairman Nottingham, that's a very good question, and I have the exact same question for Entergy.
So you've offered a through route, but you don't know, it's just an open offer of whatever it might evolve into?
There is a tariff through route that exists today. However, Entergy does want to move unit trains. They want to move them from the Powder River Basin. They have not identified whether they would move from the northern Powder River Basin, the southern Powder River Basin, or specific mines. They've not identified the railroad that the traffic would move over before it connects with the Missouri Northern Arkansas, and they've not identified the interchange point between the Missouri Northern Arkansas and the second railroad.
But you must be pretty familiar with the M&A's system map, and what would be the potential alternative through routes that might exist? I mean, it's not a giant railroad. I mean,
there are 5 different interchanges today just with the BNSF. It doesn't include the KCS. It doesn't include the Union Pacific. There are additional interchanges with them. So there would be 5 potential interchanges. I believe that in this case, because Entergy has the burden of proof, that they would be the ones to define what they believe is the most efficient interchange. They haven't done that. They haven't defined any of the interchanges. In fact, in response to a discovery request from Entergy last week, M&A extended an invitation to inspect the M&A properties to both Entergy and Arkansas Electric. We believe that instead of M&A going through all of the potential iterations of the interchanges, the different types of operations that may occur, that the best approach would be for Entergy and Arkansas Electric to conduct their inspection of the Missouri Northern Arkansas property. Then they could determine what they believe is the best interchange. They could determine what they believe is necessary to provide the service that they want, which they have not identified yet, and then they could present a second amended complaint with appropriate information that the parties could respond to, and the board could probably more expeditiously determine the case.
So, are there any constraints on your, based on the condition of your track, your client's track? Are there sections of track or parts of M&A's system that could not accommodate a unit train full of coal? And would that impact the possible menu of through routes?
We believe that we could probably accommodate a limited number of unit trains moving at 10 miles an hour. The infrastructure would require substantial investment. We have not conducted a study to determine how much that investment is. The more trains that are running, the more investment would be needed. We would be not only talking about upgrading the track to meet whatever the criteria are that Entergy might establish, but also adding sidings so that the train, it's a single line track. We'd have to add sidings to avoid meets so that the track could continue to run fluidly.
And how would the railroad recover the costs of those upgrades?
That's an excellent question. We don't know.
How does your railroad usually recover such costs?
Through the rates charged to the shipper.
Hasn't Entergy suggested that it would decide what route was the appropriate one after discovery, and they feel that it's inappropriate to dismiss the case now before they do discovery, and that after discovery they're willing to identify the route, and that would be a legitimate expectation on the part of Entergy?
What Entergy has asked for in discovery is for the Missouri Northern Arkansas to do all of the work for them. They've asked us to identify, to respond to the 5 potential interchange points. They've asked us to identify the infrastructure upgrades that would be necessary at each point and the costs for those upgrades. But they haven't told us what kind of service they want. They haven't told us how many trains per day, per week, per month, per year. They haven't told us what speed they're looking for. They haven't told us what type of efficiency comparison they're looking for in the context of this case versus the operations of the Union Pacific Missouri Northern Arkansas movement today. So we could certainly answer it, but it would be, the answer would go from 0 to infinity. I think it's better, since Entergy knows exactly what it wants, for them to go inspect the property. They have their consultants, they have their experts, they've all been invited to go on this inspection trip, and they can then determine which is the appropriate interchange point, what the costs are, what infrastructure is needed. In addition, Missouri Northern Arkansas does not have access to the BNSF lines, assuming BNSF is the partner in this interchange, in the through route. Entergy, on the other hand, may or may not, we don't know, because BNSF is not a defendant party in this case. So Entergy can determine which interchange is best on both sides of the through route, for both, assuming it's BNSF for BNSF and for Missouri Northern Arkansas. It may well be that there is an interchange point that is better for Missouri Northern Arkansas and not for BNSF.
Mr. Goodwin, there's a tariff that's referenced in the record, number 8006-C, that was issued by M&A. Are you familiar with the tariff?
Somewhat, yes.
Could you help me learn when it came into existence? Has this been a tariff that goes back many years, or is this something that just appeared in the last few months or weeks? Or
no, it's been in existence for several years.
And do you have any knowledge about why has a tariff ever been used? Has it been have customers availed themselves of the tariff?
No, they have not.
If we grant the motion to dismiss based on the tariff, would there be anything stopping you from pulling back the tariff, withdrawing it?
The tariff has been in place for quite some time. There's no reason for Missouri Northern Arkansas to withdraw the tariff. In addition, one other point I forgot to make is we invited Entergy and Arkansas Electric for the inspection trip. If the amended complaint were dismissed, we would not withdraw that request for the inspection. We don't want to hide the ball. We realize they have a case to make. We want to give them a legitimate opportunity to make their case and file the proper pleadings. We would not withdraw that request or that offer. They could come, inspect the property, make their determination on what the interchange is, what the infrastructure improvements would be necessary to meet their service requirements. They could determine, or they could at least make an offer of how they would help Missouri Northern Arkansas pay for that infrastructure, which would solely be for the benefit of Entergy.
Did you say there was a quid pro quo for that invitation, that if they did something, you would continue to do this, or that they would have to withdraw the complaint? Was that the...
No. What I was saying is if the board were to dismiss the complaint, we would not withdraw the invitation.
Okay. Thank you.
Mr. Gilmer, should we infer, based on the existence of this tariff, that M&A is perfectly happy to do business with shippers such as Entergy and consistent with the tariff, and that there's nothing that would prohibit you from honoring the tariff?
That's correct.
And are you familiar with Section 10705? I'll cut to the chase on it. The essence of it, of interest in this case, at least to me, is the statement in the statute that the board may and shall, when it considers it desirable and the public interest, prescribe through routes. And then I'll skip forward to subsection 2C. when the board decides that the proposed through route is needed to provide adequate and more efficient or economic transportation. Do you have anything to say about that provision of statute today to help us understand it more clearly?
The Interstate Commerce Commission back in the mid-1980s addressed this exact issue when it adopted the competitive access rules. And this board, when it denied the original complaint filed by Entergy, told Entergy that they could file an amended complaint under the competitive access rules at 49 CFR 1144. I don't know that, I can't cite chapter and verse of the rules for you, but the rules put meat on the bones of section 10705. They require a comparative analysis of the efficiencies between a current route and a new through route. They require a competitive analysis to see if the parties involved in the competitive route are, in the existing route are acting in an anti-competitive way or contrary to the competition factors in the rail transportation policy. And that would put the meat on the bones of section 10705.
With respect to 10705 and your tariff argument, would that tariff, is it your argument, bar Entergy from seeking a more efficient route, such as, say, Lamar?
That's a good question. I don't know if I have time left to go through that. Let me think about that and come back to that.
10 minutes, too.
Yes, thank you.
That does raise a question, Mr. Chairman. Will there be an opportunity to answer questions in more detail if necessary and keep the record open after the hearing today? If there are certain questions that parties are just not able to answer but are important to the board?
I certainly feel it would be appropriate if we felt there was more need for further briefing. If that was the case, yes.
Thanks.
I believe my time is up. Thank you very much.
Thank you. I have to go back to mine. Thank you. Now, counsel for Entergy and AECC, please step up to the podium, introduce yourself for the record, and begin.
Thank you. Chairman Elliott, Vice Chairman Nottingham, Commissioner Mulvey. My name is Michael Loftus. I am appearing on behalf of Entergy Corporation, Entergy Services, Inc. I'm accompanied at council table by my partner, Frank Pergolesi, and I'd also like to note for the board that Mr. Ryan Trushensky, who is the head of the Solid Fuels Department of Entergy Services, is here, as is Corey Kahn with Entergy's General Counsel's office. We have agreed to an allocation of time with Mr. Von Salson, who is counsel for AECC. I'd like to start by addressing briefly the standard for motions to dismiss before the board. In general, they are disfavored. That is particularly true when the case has not been through discovery and there has been no opportunity to submit evidence. In the North America Freight Car Association case, which we provided a cite to among our additional authorities, there is a statement that motions to dismiss prior to submission of evidence are generally denied to ensure that participants have a full and fair opportunity to meet their burden of proof. There is also precedent before this board that where the matter involved is one of first impression, that raises the bar, if you will, for a motion to dismiss. The indication from that precedent, if you look at National Grain and Feed Association, versus Burlington Northern is that there has to be more leeway for a complainant to make their case in the absence of clear standards. We are in the midst of discovery. We have requested in discovery much information we need in order to flesh out our case, to identify the route or routes that we believe are the most efficient and would be most appropriate for this traffic. Turning to the arguments that have been made by MNA, first as to BNSF being a necessary party, as we have pointed out, they are a party to one of the dockets that is involved in this case. Even if they were not, the board could make the comparative analysis under its regs 1144 that is called for. We have discovery outstanding to BNSF, seeking information that's pertinent to such an analysis. We do not agree that Entergy must satisfy the elements of that comparative analysis. We believe that under 10705A1, which refers to the board may and shall, when desirable and in the public interest, prescribe an analysis, that we can qualify for a prescription of a through route under that standard without necessarily getting into the long haul, short haul focus, which is reflected in the regs for that comparative analysis. Lastly, on the BNSF as a necessary party, if the board concludes that it is, if it would instruct us to that effect, we will certainly add them as a party. The second argument has to do with the contracts that Entergy has outstanding with the Union Pacific. There are two such contracts. We have explained in our amended complaint to the board what each of those contracts allows Entergy, and I should say in our reply to the motion to dismiss, the volumes that are not committed to UP under those contracts, and that we are free to ship via another arrangement. So this is not a situation where there is no traffic, that we are free to tender to BNSF, which is our assumption of who the originating carrier would be, and MNA for movement to the Independence Plan.
We can't talk about the amount of traffic, that's confidential, but are the amounts of traffic here at issue sufficient to justify opening up a line to the Burlington Northern? And along with the question I asked earlier, if the volumes are relatively small, would therefore the single car rate be appropriate if the volumes are not sufficient to require unit trains?
Starting at the end, the single car rate would not be appropriate under any circumstances, because as we have advised MNA, and I will submit for the record our response to MNA when they asked, well, what kind of traffic is this going to be, and so on. We told them very clearly it's going to be 135 car trains, shipper provided, 286 equipment, aluminum equipment, etc. Now, where the uncertainty is how much volume per year will we want to move, and so on. As to your question about whether the volumes that Entergy is free to move between now and the expiration of the second contract, is it sufficient to warrant upgrading the line? I take it to be your question. First of all, we do not know as yet what may be necessary for upgrading that line. We do not know whether, with slow orders and, moving at certain rates of speed, the line may be capable at this time of handling unit trains at a slower speed, for example. So we need discovery to figure that out. This is a situation that cries out for a contract between M&A and Entergy. But what is preventing that contract is what we tried to directly attack in the first stage of this litigation, in which the board would not address on the terms we wanted. I mean, the problem is we cannot go to M&A and say, okay, what are you going to have to do? This is how much tonnage we could commit. This is the schedule we would commit it on. This is how much we might be able to help you with financing, upgrades, all that sort of thing. We can't do that. And one of the problems in terms of the timing of this litigation is that although the board says in its June decision in this case that 10705 provides a clear approach and remedy for the precise problem we have, that's not entirely clear to us, because in our view, we get the through route we're asking be prescribed. What happens then? Well, then we ask for the rates, and then.
But wouldn't that be appropriate for a rate case?
It would.
Concerned about the rates?
Yeah, I'm not suggesting, but the problem we see is when we do that, M&A is going to say, all right, to handle that, we're going to have to pay under the terms of the lease all these, I'll call them penalty rentals, and they're going to build that into the rates. So then we're going to challenge the
Would that be considered in a rate case?
Would it be?
Yes.
Well, under the standalone cost case or approach, and I think the board indicated this in its June decision, it's not clear that those would be, I mean, you're going to be focused on what it would cost to build the standalone railroad. We would certainly argue that these payments to UP have nothing to do with that. And they're not a variable cost and they shouldn't be considered. But that's, I mean, who knows what kind of arguments are going to be raised there. Well, what's clear is that we then have to go through a rate case. Let's say we go through the rate case. We get a prescribed joint rate over the route. Well, then you've got provisions in this lease that allow UP to do one of two things. One, it can terminate the lease. Two, it can say, well, we're exercising our right to provide direct service to Entergy's Independence Plant. And M&A, you're no longer capable of doing it, under the terms of our agreement. And so where are we then? So we have great concerns about, where this is all leading. But, the board directed us down this path, and we're proceeding down this path. We will do our best. And in our amended complaint, we have asked the board to be mindful that it has to fashion a remedy at the end that's sufficiently broad to deal with these potential occurrences.
So your thought is the remedy of quoting, like we have in this case, a tariff, wouldn't be adequate because you'll need more to stop, I guess, UP from exercising its right?
Well, we're very fearful that we will go through the hoops, and at the end of the line, the UP will pull the plug and say, okay, game over, we're tired of this, and then what? That's something we would welcome all the guidance the board can, or clarification the board can provide in a decision on this or any other matter in this case. But it's a great concern to us. Yes, sir.
Well, following up on that point, if you express concern that the Union Pacific might exercise its contractual authority to, under certain conditions, to basically cancel the lease with M&A, and then you would be presumably returned to what could be called the status quo ante, or a situation that existed in the past where your client did business largely with the UP directly. No offense to M&A, we're glad that they're on the national scene. The short lines have played a phenomenally important role in bringing competition and service to thousands and thousands of rail customers around the country. But if that were to happen and UP were to directly serve you again, and you also had the ability to make your case that there is a more efficient interchange point, putting you onto the BNSF, wouldn't that solve your so-called captivity concern? But I'm hearing you reference a broader concern, which one might describe as wanting low-cost rail transportation, and that's a different concern. There's access to multiple rail lines is something that I think our decision earlier this year gives you a roadmap to pursue. Guaranteed low-cost rail service, that may be another matter. What problem are you trying to specifically solve for your client?
Well, Vice Chairman Nottingham, the specific problem we're trying to address is that in the lease the UP executed with M&A, there are what we believe constitute, in our words, a paper barrier, in the board's parlance, an interchange commitment, which should be found to be against public policy and unenforceable. As we pointed out in our legal arguments in the initial case, there are a lot of analogous circumstances where courts in this country hold various agreements void as against public policy. Now, the facts are, as we have demonstrated them in the earlier phase of the case, that there have been periods of awful service from UP, at least 3 extended periods where Entergy was severely damaged by UP's failure to deliver the coal that Entergy needed to burn. It had to curtail operations at its coal-fired power plants, and its efforts to obtain some sort of alternative transportation were unsuccessful. So yes, Entergy wants to obtain more economical transportation.
Isn't what Mr. Nottingham, Vice Chairman Nottingham brings up, wouldn't that be an example of a bottleneck situation where UP could not be compelled, as the law stands right now and as board precedent stands right now, could not be compelled to interchange with BNSF if it served Entergy and also served the mines?
That obviously is, yes, a major concern as well. Now, we have asked in our amended complaint that the board, in this case, if it orders a through route, specify that if UP terminates the lease or asks for direct service, that the board make it clear that UP itself would be required, that is, to interchange with BNSF for an alternative route.
But that would be basically requiring UP to shortline itself in the sense of to short-haul itself in the sense that was supposed to be addressed by the board's earlier bottleneck decision, and which is okay. So
it would.
Mr. Loftus, didn't Congress directly address this in Section 10705? There's a clear description that the board can decide and require a through route. You just need to show that it would be more efficient or economic. If it's to me, it's as plain as the printed word on the paper. I mean, the Congress directly thought this through and gave us clear statutory guidance and gave shippers that guidance of basically a way to proceed here. And what do you have an alternative view or definition or interpretation of that section?
Vice Chairman Nottingham, I'm not aware that Congress ever really addressed the paper barrier circumstances that exist in this case, or the interchange commitment issue. I'm not aware that that was a focus of 10705 as enacted. It's one of the reasons we didn't proceed under 10705 originally, because we see this as a competitive issue that on policy grounds this agency should rule unacceptable. You raised the point about the Union Pacific and its rights under the lease and so on. As we demonstrated earlier, we think that they've already earned under this lease what they had a right to protect through an interchange commitment when entering into this lease. That's a reason that the board should look to find that whatever legitimate role it had at the outset, that role has been exhausted, and now it's an impediment to competitive service that should no longer be permitted.
Mr. Loftus, I respect that you would like to make this exclusively a paper barrier case, but what if, in a hypothetical, what if the Union Pacific and M&A agreed to cancel whatever interchange agreement they have, or paper barrier, or possibly UP decided to return to the status quo ante and serve your client directly and stop doing business with M&A? How would that change your situation? Don't you have another problem that needs to be solved? If I've read your pleadings and also heard various testimony in Congress and other public forums from your client, that they have a captivity problem that they need to address?
Absolutely.
So the absence or existence of a paper barrier doesn't necessarily cause or solve your client's problem. It's access or lack of access to another line of railroad, which the statute provides a very clear roadmap for once you make a showing of enhanced efficiency.
There is the physical capacity as operations are now performed for BNSF and M&A to deliver coal to this plant. So Entergy, yes, it wants to break its captivity for two reasons. One, it wants better rates. Two, it wants reliable service. And it would like to do that by using the rail operations that are in place and in operation.
Do you have anything to say about 10705's applicability to a situation such as this? Do you feel it's applicable, not applicable, inadvertently written with something else in mind, or because I'm just having trouble getting beyond the point that it seems to be directly on point to the type of situation you have, assuming you can make the case that you could interchange to a more efficient routing. I mean, we have an interest as a board, a policy interest, and a larger interest in making sure that we have an efficient rail transportation system. Nobody wants to see trains routing all around the country in an inefficient manner. We've got energy policy implications to that, transportation congestion, jobs. So I mean, what interpretation do you have for 10705?
Well, we accept that 10705 applies, and we are proceeding under our amended complaint to satisfy the terms of 10705 and to obtain an order from the board prescribing a through route. As I described earlier, we are very concerned, having completed that successfully, which we hope to do, that there are other problems looming down the road, you know, if there is not some way to address those problems before this agency, you know, it's a legitimate question about how much sense it makes to go through 10705. Now, we have, after the board directed us in this direction, we sent a letter, Entergy, to M&A and said, you know, are you willing to establish a through route? Because if you are, then we don't have to go through this. There have been further exchanges of correspondence, and you know, it's possible that as this proceeds, you know, there'll be an agreement to a through route that may shortcut this process.
You believe that mediation might be helpful in this case?
I have no reason to believe so.
Okay.
I think if the parties were to feel that there was some point in that, we would certainly join in approaching the board for assistance in that regard. But
I guess my next question, with respect to, because now we have to make a decision, with respect to efficiency, you noted various examples of inefficient service from what you have at the present time, such as during flooding. Now, with this alternative route that you picture, envision, I guess with BNSF, would that have avoided something like the flooding?
You've selected one of the three episodes that we point to.
Right.
The other two were the service crisis after the UPSB merger.
Sure.
And the other was the 2005 problems. I cannot tell you what the situation was on the ground in 1994 and whether BNSF M&A would have been better able to deliver the coal than UP was. I'm sorry, I just don't know. In the other two situations, we believe the answer is yes. BNSF could have provided assistance to Entergy as it did to other shippers where BN or UP were capable of originating the coal. I see my yellow light is on, so.
One last question. Do you think it's likely that we'll have another such UPSP type meltdown?
I consider it entirely possible.
Okay.
We're currently enjoying the benefits of a major downturn in economic activity in this country. When the economy comes booming back and the rail system is stressed, it seems to me possible.
One last question also, and that is, M&A said that you were invited to go on a tour to look at some of the alternative interchange points and what some of the needs for upgraded track might be, but you've decided not to take up on their offer. Is that true, and can you explain why?
I think you must have misheard. I didn't hear Mr. Gittimer say we decided not to take them up. In fact, we requested the opportunity to inspect. They agreed. They're cooperating with us to make arrangements, and we intend to proceed to do that. I heard for the first time that they're not going to answer our interrogatories and other discovery requests, and I won't address that now because I just heard it.
But you'll be able then to determine what routes you want to identify and the like. It will be part of the discovery process then?
That's the objective.
Thank you. Mr. Chairman, can I just ask one last question?
Certainly.
Thank you. Mr. Loftus, you mentioned earlier that this is a situation that cries out for a contract, and you might be right. Contracts are important tools that can do great things, but my understanding is that railroads are not required to enter into contracts. And so if M&A or UP or whoever you're dealing with just decides to operate under tariff, that's going to be the way you have to move forward. And there is a tariff. I wanted to ask about it. We've just heard from Mr. Gittimer, there's an existing tariff numbered 8006-B. Has your client availed itself of that tariff? And if not, why not?
The answer is no, it has not. It's my understanding as well that railroads are not obligated to enter into contracts. The reason Entergy has not availed itself of that tariff is that it provides for movement in single cars. I haven't run the numbers, but my guess is it would be more expensive than the current service. We don't have any arrangements with BNSF in place or in the works to do that. I will tell you, though, but that I do believe it cries out for a contract because, in my experience, that's the best way to deal with a situation such as this, where they may need capital for upgrading, and we have an interest in making that happen, and so on. And the best way to do that is working out terms in a contract.
I understand. No further questions, Mr. Chairman.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, Commissioner. I'm Eric Von Salzen, counsel for Arkansas Electric Cooperative Corporation. AECC endorses the arguments made by Entergy. I'm not going to repeat them. But what I want to do is remind you of something that Mr. Gittimer said early in his argument, which is that the board, in its June 26th decision, provided a roadmap for this proceeding. And as is very often the case, Mr. Gittimer is clearly correct, and I'd like to sort of outline that roadmap as I see it. On page 7 of your decision, you said this. You described the claims that Entergy and AECC were making as follows. Entergy has essentially alleged an abuse of market power. Entergy is served solely by MNA UP today, and Entergy alleges that UP, in conjunction with MNA, has exploited that market power to foreclose competition. On page 6, you said, public documents suggests that the terms of the contract, that is the existing contract for the rail transportation of coal to the Independence Station, would permit Entergy to pursue rail service from a carrier other than UP for PRB coal movements in, quote, several years. And with those two thoughts in mind, you said Section 10705 provides a means to directly address and remedy the precise problem about which Entergy complains. That's the board's ruling. The board was aware of the issues that MNA has raised in its motion to dismiss, and the board ruled that this is the appropriate way to address this particular problem. So in addition to all the reasons why in an ordinary case before you, you would not dismiss a case before you'd heard any evidence, in this particular case where you have crafted or identified a way of addressing a problem that has been presented to you, it is surely inappropriate to dismiss this matter before the parties have had an opportunity to conduct discovery and come before you with a record on which you can decide what the appropriate remedy would be. As Mr. Loftus said, if you decide that you want to have BNSF as a party to these proceedings, obviously Entergy has said they'll make them a party, and AECC thinks that would be, we'd go along with it. We think it would waste the resources of the board to get, at this stage anyway, an extraneous party into a matter which right now involves problems that have been created by the interrelationship between the parties who are here, UP and MNA. Thank you. I have nothing further, but I'd be happy to answer any questions.
Mr. Van Salzen, you raise a good point. I would just add that would you agree, let me ask this, that parties need to help build the record here. The board, I mean, we can provide a roadmap, but we can't litigate the case for you. I mean, you've got to bring the appropriate parties to us at the appropriate time to help develop the record. And this applies to all the parties, but it's as one commissioner, I will just say I will be looking with anticipation at whether all the parties that should be fully engaging on this and working towards an actual resolution of this case are helping do that. I worry sometimes with the stop and start nature of this, and that not everyone is leaning forward enough to help us get to a resolution in a reasonable time and at a reasonable cost.
I think certainly Entergy and AECC are interested in moving forward as expeditiously as possible to develop a record. I think the response of MNA in the form of the high rail inspection trip is certainly a productive start. We'll just have to see whether we run into any roadblocks along the way, and of course if we do, then the board will learn about it. But I'm trusting that we will be able to present a full and adequate evidentiary record for your decision. Thank you for your time.
Mr. Gittimer, I believe you have 10 minutes for rebuttal.
Thank you, Mr. Chairman. In answer to Vice Chairman Nottingham's question earlier about whether MNA's existing through route prohibits the establishment of an additional through route, I believe that if Entergy were to bring an appropriate case under Section 1144, that a through route could be prescribed by the board. Again, that's my off-the-top thinking, having been given about a half hour and no additional research. But that's my thought on that issue. One item that Missouri Northern Arkansas wholeheartedly agrees with Entergy about is that Missouri Northern Arkansas does not want to see the lease terminated. Were the lease to be terminated, Missouri Northern Arkansas most likely would cease to exist. The line may go back to the Union Pacific, and the Union Pacific would do with it as the Union Pacific deems best. And we're not going to speculate on that. But the short line would cease to exist. The employees would cease to be employed by the short line. The shippers that receive some competitive service from the short line would no longer receive that service. As Mr. Loftus did say, this is a matter of first impression, but before the board, and we believe it's very important for the board to get it right as far as setting up the procedures that the party should follow in a matter of first impression, especially if there are going to be a number of proceedings following it. And that's why we think it's very important for all of the defendants to be named in the amended complaint, which they were not. Mr. Loftus also stated that the complainants need discovery in order to provide facts to the board. They don't need discovery to say that BNSF is a co-defendant, not just a party, but a defendant. And I beg to differ with Mr. Van Salzen very strongly when he says that BNSF is an extraneous party and it would lead to delay by including them in the amended complaint. As you well know, through routes involve more than one railroad. You can't prescribe a through route over just the Missouri Northern Arkansas. If you're going to prescribe a through route, you need a partner. Apparently the partner that's been chosen by Entergy and Arkansas Electric is the BNSF. I believe there are grave questions whether you can prescribe a through route over a railroad that is not a party defendant to the complaint.
Mr. Gittimer, do you agree that if the board felt it was in the public interest, we could, on our own motion, make the BNSF a party in order to more fully develop the record in what might be an important case, and just eliminate the drama and suspense, just move forward?
Certainly, these are the board's procedural rules. The board can adapt its procedural rules as it sees fit, whether it be on its own motion or not. However, I caution that under the procedural rules, a defendant to a complaint is entitled to answer the complaint. So that I believe BNSF, were they made a defendant, would be entitled to respond to the complaint.
You mentioned the possibility of UP was to terminate the contract with M&A and M&A was to cease to exist, and that UP then once again began providing the service directly to Entergy. What would be the implications for UP for doing that? Wouldn't there be costs associated with running that service again, that UP, after all, is a Class 1 carrier and would come under some of the regulations, especially labor regulations, that M&A does not have to comport with?
I did not speculate on what UP would do if they terminated the lease and M&A ceased to exist. If we're going to speculate, certainly UP could take the operation over again. UP could short line the line. UP could abandon the line. There are obviously other possibilities there as to what UP could do. Were UP to take over the line again, I believe UP would continue to be subject to the same regulation that it's subject to today. And indeed, I believe under the lease, that the Union Pacific has the residual common carrier obligation to operate those lines, were the Missouri Northern Arkansas to discontinue its service over those lines.
Mr. Gimmer, if it's hypothetical, but you raised it, if the UP were to abandon this line under some future scenario, wouldn't parties have an opportunity to buy the line in the course of proceedings? For example, a large, successful energy company, for example, and therefore exercise a little self-help?
Certainly under the board's rules and the statute, any party can acquire a line that's been authorized for abandonment by paying the net liquidation value for the line, yes.
Submitting an OFA, and we would then look at the NLV to see what they should be paying as an OFA, correct? The Office of Financial
Yes, unless the line had a going concern value, and I believe the board's precedent is that in abandonment cases there is no going concern value, and therefore the board looks at the net liquidation value. And the question, I think, then would become an economic question for the utility company to determine whether it was willing to pay the net liquidation value for the line, whatever that may be.
Mr. Gittimer, it might help. There's been some reference in the record to the landscape we're talking about here that your client's railroad operates on. This is not, my understanding, this is not all the wide open, flat, dry prairies. This is some pretty severe terrain, and we've had other cases recently, Coos Bay, one in Oregon. We're familiar with tough terrain, but could you just try to give a little context for some of us are not native Arkansans?
There are a number of tunnels and bridges along the line. The line runs along the river in a number of places, and we believe that to handle any substantial number of unit coal trains, the line would require substantial infrastructure upgrading. It's not easy terrain to operate in. It's not straight and flat.
And I appreciate your reference to an offer of to Entergy to go on a tour of the line, inspection. Would your client be willing to discuss jointly hiring an independent engineering firm along with the other parties here to get a independent assessment of the condition of those lines? That one might anticipate that of itself, after you have the pleasant trip and inspection, we will be hearing about two versions of what in fact the track condition is, and we'll have to choose amongst the two versions. It might be helpful to have an independent engineering firm.
I think we'd certainly be willing to talk to the other parties about it. Whether we could arrive at an agreement, I'm not sure.
I would commend that to your consideration and the other parties as well as we move forward here. It just might save us everyone time and money. I mean, I envision dueling engineering reports, hundreds of thousands of dollars, millions of dollars each, and it's all pretty avoidable. You get a reputable engineering firm, they're going to call it as they see it, and then you can not argue about it if you can work out that agreement.
If we can find an engineering firm that's not tied to one of the parties.
Fair enough.
Again, let me emphasize that the point of agreement between Missouri Northern Arkansas and Entergy is that Missouri Northern Arkansas wants to keep the lease in place, continue operating over the line, providing service to its customers, including Entergy, which it serves today. One further point that has been made in this proceeding and in the prior proceeding are the service problems which Entergy has suffered because of the Union Pacific. I must point out that none of these service problems have been caused by Missouri Northern Arkansas. Missouri Northern Arkansas is not a party causing service problems, although we are the party over which the new through route is being sought. I urge the board to dismiss the amended complaint, allow the inspection to go forward, and then allow Entergy to file a second amended complaint seeking specific relief and specifically naming the parties to the relief which they seek. Thank you for your time.
Thank you very much, counsel, for your excellent presentations. We will take the matter under advisement. We will now hear oral argument in STB Finance Docket number 34914, DesertXpress Enterprises, Petition for Declaratory Order.
Chairman, I note that we might need a little more water for the attorneys at the dais, if staff could help with that. Thanks. Didn't mean to have the chairman for the water, but that's...
I come from a labor. Counsel for California Nevada Super Speed Train Commission and American Magline Group, you have 40 minutes. Again, please introduce yourself for the record, indicate if you have reserved any time, and then begin.
Chairman Elliott, Vice Chairman Nottingham, Commissioner Mulvey, good afternoon, excuse me. My name is Robert Valmeigen, and I represent the joint petitioners, the California Nevada Super Speed Train Commission, the American Magline Group. I will refer to my clients in this argument as the Commission and AMG. Joining me today is Joyce Gresco, who is a colleague at Foley and Lardner and who assisted me in the preparation of the argument. Also joining us today is Neil Cummings, who is the president of AMG. I will reserve 7 minutes for my rebuttal argument. The commission is a 16-member bi-state commission with 8 members representing California and 8 members representing Nevada. It is also a nonprofit public benefit corporation and a state agency of Nevada with statutory powers granted to issue a franchise to a private sector partner to design, build, operate, and maintain a super speed train system. AMG was selected as that private sector partner. AMG is a joint venture comprised of General Atomic, Parsons Transportation Group, Hirschfeld Steel, and the law firm of M. Neil Cummings and Associates, PLC. AMG is an exclusive contractual relationship with the developers and owners of the Trans-Rapid Maglev technology. The central issue raised by the Commission and AMG in their joint petition relates to the subject matter jurisdiction of the board. The issue is, has Congress granted the board jurisdiction over passenger-only rail carriers operating over trackage that is separate from, not connected to, and therefore not part of the general system of rail transportation, or of the interstate rail network, as described by 49 U.S.C. sections 101.02, 5, and 105.01A2A. Congress has not done so, and the board's June 27th decision did not reach the right conclusion, in part because it did not have the complete facts about the Desert Express operation before it, and in part because the entire thrust of the Desert Express petition was to elicit a declaration related to the scope of preemption under 105.01B on the presumption that the jurisdiction was conferred by section 105.01A. The board's own words at page 2, in its slip opinion, quote, Desert Express argues that this project presumptively falls within the board's exclusive jurisdiction. There are no facts which justify presumption of jurisdiction in this case. I intend to cover the following issues in my argument. First, I will show that nothing in the ICC Termination Act or its sleight of history supports the Desert Express belated contention that a separate and unconnected high-speed rail, passenger-only rail line can nevertheless be, quote, part of the interstate rail network. To the contrary, Congress restricted the board's role over passenger transportation to a few limited circumstances where conflicts between freight and passenger operations require board resolution. Second, I will draw attention to what the ICTA does not say. I will attempt to demonstrate that without further direction from Congress, the board is in no position under the existing statutory authority and its regulations to exercise exclusive jurisdiction over the operations of passenger-only intercity rail entities. Currently, FRA and the states have jurisdiction over those operations, and the STB should not step in without further direction from Congress to do so. The decision that was served yesterday by counsel for Teamsters in the Joseph Fox case is of interest to me. I don't quite know what the argument is going to be, but if the suggestion is that this is the passenger rail lines ought to be considered in the same category as switching tracks, spurs, or team tracks, where the board has exclusive jurisdiction but does not have any authority to regulate, I think that would be a disaster for the passenger rail network. So in any event, we will make the argument that the board, what the ICTA does not say is as important as what it does say. I also will show that the petitions to reopen under 49 CFR 115.4 may be filed at any time, and the board's June 27th decision contains material error. Moreover, this joint petition has resulted in Desert Express admission of new facts never before presented to the board, which justify reopening this proceeding to correct the fundamental error made in the board's June 27, 2007 decision. And finally, I will respond to the procedural arguments made by Desert Express and Teamsters, which do not relate to the basis for the board to deny, do not create a basis for the board to deny the Commission and AMG's joint petition to reopen and intervene in this proceeding. Desert Express investment in the FRA draft EIS is not wasted. However, as the board well knows, detrimental reliance does not confer jurisdiction upon the board if Congress has not granted such jurisdiction. April 28, 2009 is a significant date in this case, for it's the date upon which it received the Desert Express reply brief. The STB learned for the first time in that brief what rail operations Desert Express believes are encompassed within the board's jurisdiction. In its reply to the joint petition, Desert Express states that the rail tracks over which it was going to hold itself out to the rail passengers will not be connected to the interstate rail network and with the general system of rail transportation. That's at reply 10 to 11. The reply states at present physical connection is to the larger system of rail lines is not a prerequisite for the board's jurisdiction. But in footnote 4, waffles by suggesting that if the physical connection is required, perhaps the contiguous right-of-way with no connecting tracks might be sufficient, citing our joint petition. Certainly, it is not our position that a contiguous right-of-way is sufficient under ICTA and the STB precedent. The precedent shows that even if the tracks of interurban electric railways connect directly with the interstate rail system, unless significant quantities of freight are interchanged, there is no jurisdiction under the Act. And the cases cited in our pleadings, Piedmont and Northern Railway versus ICC, Texas Electric Railway, Railway Labor Executive Association versus ICC. The Desert Express vision is for a separate high-speed passenger network. Quote, Desert Express hopes to have its line operate as part of the nation's first true high-speed passenger rail network, close quote, at page 11. The reply at this point is speaking about its future plans to link with the California high-speed rail project at Palmdale, California, which does not claim that it is a rail carrier under ICTA, and which is complying with state law in processing of its rail project. Desert Express vision is premised upon having one or more separate high-speed rail passenger networks that do not serve shippers along their routes or connect with the interstate rail network of freight railroads, but there is no support for this in ICTA. The Desert Express contends that the board, quote, is clearly the appropriate agency to exercise jurisdiction over passenger-only rail lines. It also alleges that the theory advanced by the Commission and AMG that the board has no jurisdiction over the passenger-only high-speed rail network, quote, it simply cannot be, close quote. I have high regard for the competency of this board and the staff which supports it. But until Congress...
With respect to your argument regarding the passenger, and as I understand your argument is that we don't have jurisdiction over the passenger service. And how do you reconcile that with sections 10102, section 9, that refers specifically to passenger service?
There's no question that the board has jurisdiction over transportation, rail transportation that includes passenger service, but it's only as part of the interstate rail network.
So you are conceding that we do have jurisdiction? So that, okay.
No, you have jurisdiction over passenger rail in the context, as long as it's provided as part of the interstate rail network.
And that has to be on the freight system, is what you're saying?
That's exactly what I'm saying.
Okay.
Well, the exclusion that's quoted here is does not include street, suburban, interurban electric, not operated as part of the general system of rail transportation, or collectively as street railways. Now, Desert Express is not a street railway, is it not?
Well, I wouldn't think it's a street railway, but I would say it's an interurban electric railway. And that's
interurban electric railway is the intra-urban electric railway.
No, it's not. It's interurban.
It's interurban, and you consider interurban in this case to be
I'm
something
saying
as long
it's between two cities, one of which is Victorville, California, and the other is Las Vegas.
Well, most of the old interurbans were a little more proximate than almost a 200-mile
We have 100,
stretch,
particularly in the case,
160-mile stretch.
Excuse me, Chairman. I mean, Commissioner Mulvey. The one case involving a commuter, an interurban railway in the Sprague versus Sprague case was 117 miles. We've got a 200-mile railway here. That was a case these early cases were decided when the board didn't have jurisdiction over intrastate transportation. Clearly, it does today under 10501A1A.
The 117-mile case was what rail line?
There was a rail line from downtown Chicago to Elgin, Illinois.
All within the state of Illinois.
All within the.
This is interstate. Last time I looked,
no longer that's
California, but now California and Nevada. This is an interstate.
I understand.
As opposed to interurban railway. It would also, by the way, strike me though, it would include maglev. That wouldn't maglev. If the board was to decide that indeed it did have jurisdiction over a Desert Express, wouldn't that also include maglev? That the board should also exercise
my position
over
is
maglev?
No, I don't believe that's the case. And I think the interstate rail network is not, and it could not be operated as part of the interstate rail network because it cannot interchange freight with the freight railroads, and it would not interconnect with them. So I just don't believe it's part of the general system of freight transportation, rail transportation, and it's not part of the interstate rail network.
But maglev has been declared to be a railroad, at least with respect to FRA rules and regulations.
That's correct. It's a railroad.
RLA and FELA and the rest. It has been declared to be a railroad operation. Theoretically, maglev could also be configured to handle freight. My understanding is there is some research going on looking at freight maglev systems as well as passenger ones. Is that not correct?
I'm not familiar with that research, Commissioner.
Down at Old Dominion University, they're looking at that slow-speed maglevs, which would also be freight. And of course, in that case, the freight, of course, could be interchanged with in fact, what it actually envisions is moving freight out of port areas by a maglev much more quietly, efficiently, and cleanly to a yard outside of the city where would then be transloaded onto a freight train.
That's a different scenario than we're dealing with here, where the admission is that it's a passenger-only railroad, and that's certainly the plan for AMG and the California-Nevada Superspeed Train Commission. They are planning a passenger-only rail segment between Las Vegas and Anaheim, California.
What if it interchanged with at Los Angeles, for example, with Amtrak trains, so that people could transfer from the Amtrak trains to the maglev, et cetera? Wouldn't that also begin making it part of the overall interstate rail network?
No, because it's not the freight network. My own view is, or our position is, that the cases are clear that unless you have freight involved, this is not either the general system of rail transportation, and it's not the interstate rail network. The cases all point, they looked at these interurban systems back in the 1930s and more recently, even they look at these systems to determine whether or not they are interchanging freight. First of all, they have to have a connection, and then they have to find out whether a significant portion of that activity relates to freight. If it is a rail carrier under the Railway Labor Act and under the Interstate Commerce Act. And I concede that. But in the current circumstance, the passenger-only railroad with no connection with the interstate rail network, you don't have jurisdiction over that circumstance.
Mr. Von Eigen, what would your position be if the rail carrier here, DesertXpress, amended its business plan to carry some parcels for the Postal Service?
Well, I think that gets, first of all, it's not connected to the interstate freight network. If it decided to bring a truckload of express shipments, I don't believe that would be regarded and satisfy the board standards.
You've referenced the interstate freight rail network several times. Where are you? Is there a citation there, or is there a document that Congress references? Where would one look to? And I guess the related question: that where historically has Congress looked for answers to what is or is not part of the national rail transportation system? Where does that expertise lie?
Well, I believe the legislative history we cited from ICTA is helpful in that regard, and they basically said that the ICTA totally removed the passenger jurisdiction from the Surface Transportation Board, because the only intercity passenger service at the time was Amtrak, and that was regulated under a separate statute, which is the Rail Passenger Service Act of 1970.
But wouldn't you agree that Congress is quite familiar with this agency and our capability to play a constructive role vis-a-vis passenger rail? For example, as recently as the FRA reauthorization and the passenger rail bill of last year, we were granted significant new authorities to resolve disputes regarding service between Amtrak and freight railroads.
That's absolutely correct, Vice Chairman Nottingham. But those are specific enactments that direct the board to look at the conflicts between passenger rail and freight rail, and it only could happen on the freight network. The Congress has not enacted any statute that gives you a jurisdiction in any other particular context.
Let me ask you about that, because transportation in Section 9 of 10102 is defined as related to the movement of passengers or property, or both, by rail. I couldn't imagine a more clear authorization. Are you saying that Congress, that was that was a mistake of the pen that we should just go ahead and correct because we're wiser than the Congress, or what is your assertion there?
No, I don't believe that. I think that's not a mistake. I think it is transportation within the board's jurisdiction if it occurs on the interstate rail network. And the board, as it has made clear in the state of Maine cases and all that follow it, if the passenger rail operation has some ability to conflict with the freight rail performance of the common carrier obligations of the freight railroads, then under those circumstances the board will assert jurisdiction, and it should. And that's the reason that language is in the bill in ICTA today and was retained in there. Here was a statute that was written 501C was written by and totally revised by ICTA, and then the legislative history of it says that we intended to get them out of the railroad business. So, and if these operations to be regulated, they'd be regulated, if at all, at the state or regional level.
Can I follow up on Mr. Nottingham, Vice Chairman Nottingham's point? With respect to that language, do you think that language is that he cited in 101.029, do you think that language is clear, that it takes away the jurisdiction from us with respect to passenger only on a freight system, or do you think that language is ambiguous?
I think you read it with the jurisdictional language of the board under 105.01A2A. In there it says you have to have a rail carrier providing transportation, okay? I don't think DesertXpress is a rail carrier, but I do think they're providing transportation if it were on the interstate rail network. And but they are not part of the interstate rail network because they do not connect with it. I think there's no doubt that Congress, in my judgment, there's no doubt that Congress was referring to the general system of rail freight transportation, which is over a network. I looked up the definition of that network is not defined in the statute. I looked up the definition in the New Webster's Dictionary the other day, and it basically speaks in terms of connectivity. I can read the exact quote for you, but it basically, Webster's Dictionary states, the network is, quote, a system of roads, canals, veins, etc. that connect with or cross one another, close quote. The term network denotes a connection or intersection. Sharing a contiguous right-of-way does not cut it under that definition.
But doesn't the network have to start somewhere?
The network does start. It's a 150,000 miles of rail freight track in this country.
With respect to high-speed passenger service?
Oh, I believe that it will. Those networks will start. I think they're starting today in California. They will start. There will be a network started in between Las Vegas and California.
And if they start connecting to that line all over the country, and at that point, would you feel that was part of an interstate network?
I think that's a network that would be regulated. They would be railroads and railroad carriers under 20102. And they would be regulated by the Federal Railroad Administration and state and regional agencies until Congress passed the law to give you direction on how. I think you would be the relevant board to give you instructions on exactly on what basis do you issue a new permit. Are you going to issue more than one permit in a given market? That is the rule under freight rail situation today. Is there going to be a special rule for passengers where you're concerned about the viability of these passenger routes? That's one policy kind of question. What relevance does opportunity cost, standalone cost, have to decisions about passenger railroads? Your system is set up for abandonments of freight railroads, for rates charged by freight railroads, by a common carrier obligation that applies to every inch of the interstate rail network to serve shippers. These new common carriers you're talking about over this new passenger rail network, in which DesertXpress is talking about, can't move a pound of freight.
It also applies to new construction. And I think what we're talking about here is whether or not the board's jurisdiction applies to certifying new railroads for new construction. And in part of the existing rail passenger service in this country mostly operates over the freight network. And the presumption would be that at some point, the DesertXpress, or for that matter even Maglev, as part of its overall operating plan, would be interacting with the rest of the overall Amtrak and or other freight railroad, part of the freight railroad network.
You asked a question about that, and there would be intermodal connectors. Anaheim is designing one today for the the California-Nevada Interstate Maglev project, which AMG and CNSST are developing, and that would be intersect with the Metrolink, which is a commuter rail, which would intersect with interchange. But those are not actually connections; those are basically serving a terminal.
Using the term intermodal, but we just said before that Amtrak has been designated a railroad mode of transportation, that it is not to be considered differently from railroads in general, even though the technology is different. The Congress has said that it is a railroad, for whether you think that's the correct designation or not, but it is not something. It is not one of the exceptions here in the street railway network, nor is it another mode of transportation like buses or airlines or what have you. It is considered to be a railroad. So it's not really an intermodal connection. It is an intramodal connection with regard to Amtrak, say, for example.
But I think that, Amtrak is different than the freight railroads. It was at one time considered a rail carrier under the Interstate Commerce Act. It's now clearly not. It's a railroad under 20102 of Title 49. And I think what we're talking about is systems that will not be able to interconnect. You cannot operate a high-speed passenger rail only train on I believe even in the corridor where you've got a freight right-of-way. And I think the freight right-of-way, the administrators of the freight right-of-way are raising those issues today. And through testimony we cited in our joint petition by the chairman of the BNSF Railway, that you have a 150-mile-an-hour train, which DesertXpress is planning to build. It just cannot cohabit with a freight right-of-way, with a freight train line in a right-of-way that is owned by the freight railroads. So
those are operational limitations because of the interaction between the two, the possibility of accidents, the absence of PTC, and what have you. But theoretically, of course, you could do it. But in the case of maglev, it's not even theoretically possible because the technologies are different. But is that sufficient to remove it from the freight rail network?
I think physics prevents it too. I think that's Mr. Rose's argument that the curvatures and so have to be much different. You can't have them occupying the same right-of-way. I think there's some concern about safety of it too. But
Mr. Von Eigen, if I could return to the actual statute at hand, 10102, Section 5. Quote, rail carrier means a person providing common carrier railroad transportation for compensation. And then moving forward to Section 9, transportation includes any kind related to the movement of passengers or property or both by rail. So there is this linkage, and hasn't there pretty much always been in the interstate commerce area between what is deemed as rail transportation also goes hand in hand with the common carrier obligation. Are you suggesting, by following your logic, that DesertXpress would not have a common carrier obligation? They could tell people with red suitcases that they're not allowed to travel to Las Vegas because that's corporate policy, or what? Or you just believe we should sort of pick and choose and decide? I mean, ignore some parts of the statute but not others.
I don't think they could. Well, first of all, I don't believe they qualify under the definition of rail carrier, not because they're not in a position to hold themselves out without discrimination to all the public. I think it's because they're not operated as part of the general rail system of rail transportation, and that is the second element of the test for what constitutes a rail carrier. And I don't think you can ignore that. The June 27th decision did, and I think that's the error. It ignored the second half of the definition of rail carrier, and it didn't even mention 10501 2A. And the test there, which is it a part of the interstate rail network? And the decision doesn't even discuss it.
Well, on the question of whether or not this is interstate rail service, couldn't one argue that historically Congress has looked to this agency for expertise in that area, and we get a fair amount of deference? And here we have a railroad purporting to seek to serve the public with a common carrier obligation, operating among two states. I would hazard to guess we would not have a system of national interstate rail service if, when the first one got started, an opponent had come, such as yourself, and said, "Oh, it's not connected to all 50 states or 50,000 miles. It's just the two states." I mean, you've got to start somewhere. Following up on the point.
First of all, they are starting up the rail network, and you could go forward and get your permits within each state and build the rail network. Now, the STB does have competence certainly within the rail transportation area, but I would suggest that the current statute doesn't give you any direction on what to do in passenger rail context. In 1995, the Congress was telling you that you were getting out of the rail regulation. They stripped provisions relating to rate making with respect to abandonment of rail services. Those things were taken out of the statute for good reason. They didn't think there was any relevance to it. Now that circumstance may well change and may be changing now. And that's a mission for Congress, but not for this board to start filling the gaps with no standards, really no standards. We don't have, the decision on 10901, Commissioner Mulvey raised it. And my own view is that the rules would be different. You would have to try to make a decision. Is this the best service in that quarter? You would have to ask different kinds of questions than you ask a private, for-profit freight railroad when it's going to invest its own money. Therefore, it's going to take its own risks, and you don't second guess those judgments. You take a look at whether or not if it improves competition, that's a good thing. Whereas in the passenger rail network, you're going to have a different question. Are you going to affect the viability of the better? And do you have to, should you permit a second railroad in a particular passenger corridor? There may be some that you can, but I'm just saying those standards are not decided. You have no precedent to deal with that issue.
Mr. Vaughn, I would hazard to guess that, and I'm speaking just as one commissioner, this board is open for business. If you or another railroad would like to bring us a construction application or a declaratory order on that issue, I don't think we've made any statement that we have a favorite preferred rail project between California and Nevada. Generally, this board is, likes rail transportation, and the more the better. And coincidentally, we have a president of the United States who seems to agree right now. We have a major national initiative going on, which it's hard not to think about that macro policy question when we look at the legislative history. The same reasons that brought us the strong preemption that has existed for so long is, if we follow your logic, would not apply to passenger rail right at the very time when arguably it's needed most to get this economy back going and to accomplish the president's vision for moving forward on these important passenger rail projects without having to get 100% sign-off from every state agency and local agency that might have a desire to add 5 or 6 or 7 stops, not make it so high speed. The history books are full of problem areas in that regard that gave rise to preemption. And what do you have to say about that?
Well, I think we're a nation of laws and rules, and I think we have to follow them. I think you were not given the jurisdiction to do what you just described. And I believe that Congress had no intention to have you regulating a separate interstate rail passenger network. If they would have said that if they meant it. The word passenger appears 4 times in between chapters, in 4 sections of all the chapters in Part A of Subtitle 4. And not one of them gives you that right. One relates to emergencies. If Amtrak closes down, what do you do for commuter railroads? It says that you have to, if you're on the general system of freight service, you're to require the carriers to provide a system for interchange, which is all consistent. If you have a 4-passenger railroad operating on the general system of rail transportation, I believe you have jurisdiction there. Where I differ is that you don't have jurisdiction in the context of a new railroad. And what's so wrong with regional or states making decisions about what's appropriate? They can get together in compacts and make joint decisions. The commission that is set up under Nevada law, contemplates participation by both states in the process. And the governors of the two states have just recently signed a deal to work out the details of the California-Nevada interstate maglev project. So my own view is that and our client's position is that that the board was not given this jurisdiction, and that there's nothing in the act itself that authorizes it, that the June 27, 2007 decision failed to make key findings relating to the connectivity to the interstate rail network, and it's both a component of the rail carrier definition, and it's a component of the broad jurisdiction of the board under 10501A2.
I noted in what Vice Chairman Nottingham was mentioning earlier with respect to 101029, transportation obviously refers to passenger. And then with respect to 10501, Congress clearly carved out an exception for local authorities and mass transportation. And my concern here is that there doesn't seem to be a clear cut exception for this type of traffic you're referring to. And if Congress has gone ahead and made that effort, who are we to judge whether or not they made this exception also that's already been clearly written?
Well, I think if it's transportation on the interstate rail network, the freight network, which I believe was what's referred to in that language, and there's no evidence anywhere that I can find in your jurisprudence or in the legislative history that would suggest that refers to a separate passenger network that doesn't connect with the general system of rail transportation.
Mr. Von Eigen, do you think this is a situation that would be helped through a rulemaking process if the Federal Railroad Administration and the Surface Transportation Board jointly received comment on the question, recognizing that there seem to be a number of new and prospective high-speed rail projects blooming across the country with the availability of significant funds now, public funds? We could just do a rulemaking and presumably take the statute and fill in any gaps and then have guidance out there. Would that address your concerns?
No, because I don't believe that you were given the jurisdiction to do that if it's not part of the interstate freight network. I don't believe that you're a rail carrier under ICTA unless you're part of that network. And I don't believe you have jurisdiction under 10501A2A unless you are connected with the interstate rail network. And that's what the language says. And I don't think there's any doubt what the Congress was talking about in 1995.
Well, we're talking about, as Vice Chairman Nottingham mentioned, a lot of new construction of higher and high-speed rail. Mm-hmm. And you're suggesting that there should be a distinction between higher speed rail, where we're talking about, say, extensions onto the existing freight railroad network in order to provide higher speed trains and to connect other places that would also operate over the existing freight rail network, and then whole new constructions that are going to allow true high speed, like, say, for example, the California corridor from San Francisco down through to Los Angeles, and you would treat those as completely separate, and they were one's part of the interstate system of railroads and one is not. So one would be subject to board approval for new construction, and the other would not. Is that your view?
That's my view. The California rail high-speed rail system is developing exactly that way. They don't consider themselves a rail carrier under ICTA, and they're not seeking preemption of state and local law. They're complying with all the state environmental regulations, and that's part of the process.
But in that case, it's purely an intrastate operation as well. It's not interstate. But
they're the
California Nevada, the one that you're supporting here. I mean, I'm very familiar with it because I was first involved with it more than 20 years ago. It's been around for a long time, and has the fact that it does not have federal preemption, has that been any way detrimental to the development of this, or has it always been simply a matter of money?
Well, it's been a matter of money. It's been a matter of getting Congress to pass laws that permit us to go forward. But it's not preemption. The compliance with state and local law has not been an obstacle.
Well, part of it did get some revenues, I guess, when it was designated. At least the part from Las Vegas to Primm was designated as part of one of the 3 experimental routes for maglev, and that's quite a while ago now, right? But no progress has been made on that either, right?
Well, it's not true. We basically have gotten. It took us, first of all, to June of 2008 to get the language cleaned up so that money could be expended, and then the investors at AMG had to put up the local match after exhausting a remedy there, trying to get the states to put up the money, but with the economic downturn, they didn't have the funds. So now we've got that money. Now we're waiting for FRA to give us a cooperative agreement. They promised to give it, but we don't have it yet. We're waiting for it. We begin that work tomorrow. If they'd sign the law that was allocating the money to the AMG, the California-Nevada Interstate Maglev project.
Thank you.
Von Eigen, you referenced FRA. Is it your position that maglev transportation operations are subject to FRA oversight and jurisdiction, but not any federal economic regulation, such as the type of regulation the STB handles?
I believe that's the case. I don't believe the board has a structure in place to regulate these entities, and I don't think it's been given the authority to do that.
But it's basically rail. You go to the Federal Railroad Administration because you're operating something that's basically a railroad.
It's a railroad under their statute. They have special regulations that govern the operation of these high-speed systems, and they have a structure there to deal with these entities.
You're not arguing that this is a whole new mode. You know, it's not. It's neither aviation nor barge nor trucking nor railroading. You're saying it falls within railroading for general regulatory purposes, such as the FRA.
Well, I mean,
oversight over.
FRA is. I think maglev is a new technology that is
New technology.
Yeah,
newish.
And it operates. It doesn't touch the steel. It goes up 10% grades. That's the reason it goes over the Cajon Pass, and it goes at 300 miles an hour. Those are all new factors.
But all modes have new technologies. I mean, commercial aviation's a little different today than it was 30 years ago, and as is most of the modal modes.
But I don't believe that the board's current jurisdiction was extended to these entities.
Thank you.
Thank you.
DesertXpress, please. Council, you have 30 minutes.
Thank you. That's no problem. Good afternoon, Chairman Elliott, Vice Chairman Nottingham, Commissioner Mulvey. I am Linda Morgan, and I'm here as counsel representing DesertXpress Enterprises, LLC. I'm joined at the table by Charles Vance, nicknamed Chip, who has been working with me on this project. And also I have in the room Thomas Stone and Andrew Mack, who are officials with DesertXpress. The specific question before the board today is whether it erred in concluding in 2007 that it has jurisdiction over DesertXpress. We submit that the board did not err. You reached a sound legal decision based on accurate and relevant facts, and nothing has changed that would call your decision into question. This oral argument today is about more than a petition to reopen in a particular proceeding. With the heightened interest in high-speed passenger rail, the nation is embarking upon an exciting new level of advancement in rail transportation that will be felt throughout the country. As the agency to which Congress has entrusted broad jurisdictional authority over the nation's rail transportation system, the board clearly should have a role in this initiative. The 2007 decision is consistent with congressional intent and should be upheld. Having reasonably relied on this sound decision, DesertXpress would be unfairly disadvantaged if the board, over 2 years later, were to grant this petition to reopen and intervene. We urge you to deny this petition. At this point, I would like to address some of the questions that you all have asked, because I think the dialogue to date has been very important in the context of today's oral argument. First of all, I differ with the petitioner. The ICTA statute and precedent gives you the jurisdiction over this matter. I know that the petitioner has argued that it does not, but we disagree. And we disagree because ICTA reflects the broad jurisdiction over rail transportation that Congress intended for this agency to have. If you look at the statute itself, and there's been discussion here today about the statute and the words of the statute, there are specific examples of congressional intent regarding the expansiveness of the STB's jurisdiction. ICTA, for example, granted jurisdiction even where lines are entirely in one state, under 10501A2. The definition of rail carrier is broad, as this agency reflected in the American Orient Express case, which you cited in your 2007 decision. Both passenger and freight are included in the definition of transportation. And again, I will repeat the section that has been discussed earlier, which is 101.02.9. Transportation is defined to include equipment and services related to the movement of passengers or property, or both. Passengers are clearly included within the jurisdiction of this agency under ICTA. Preemption under ICTA is expansive, and this agency has dealt with that issue quite extensively. And I will just cite in one case, the CSX case involving the Georgia Public Service Commission, which has been cited in other documents submitted. There's a quote that says, "It is difficult to imagine a broader statement of Congress's intent to preempt state regulatory authority over railroad operations." And furthermore, with respect to preemption, under ICTA, even where the statute specifically exempts certain rail lines from the exercise of certain regulatory jurisdiction, case law has made it clear that preemption still exists, and that's section 10906, which refers to spur and sidetracks and so forth. Fifth point about the expansiveness of the statute and of ICTA is the express exclusions are few. Mass transit is specifically excluded, and we've cited that statutory provision today. The interurban electric railway exclusion, and then finally private track, which has been excluded in the context of the agency precedent. So again, if you look at ICTA, expansive jurisdiction over passenger and freight, few exclusions, expansive preemption, and if you look at the case law in this area, you will see that the courts have embraced this notion of expansion. Again, I refer to the CSX Georgia Public Service Commission case, in which the court talked about transportation by rail carriers as being all-inclusive. And in the Norfolk Southern Austell decision, which again is cited in materials that you have before you, there again the court talked about the breadth of ICTA preemption, and a quote in that decision that talks about ICTA's grant of exclusive jurisdiction over the majority of all matters of rail regulation to the STB. So again, ICTA, in our view, provides the basis upon which you can exercise jurisdiction in this area. In addition, there is nothing in the statute or the precedent that precludes the STB from exercising jurisdiction in this area. Of course, as we all know, many of these cases are fact-specific, and the board has looked at a variety of factual situations and looked at a variety of factors, and depending upon the case, a particular factor may become more important than another factor. The case that was that the petitioner cited earlier regarding intrastate transportation, obviously the not having a connection was important in that case. Furthermore, we've talked a lot about the connection issue, the issue of connectivity. And if you look at the cases, existing connection is a factor, but it is not the only factor, and it is not necessarily dispositive. And again, the Fox case that was mentioned earlier is one example, several rails to trails cases that reflect this. So again, an important issue, but not the only issue, and not the dispositive factor. And I might say, with respect to the connection issue, that it is possible that DesertXpress will connect with the California federally designated high-speed rail corridor at some point. So, and that's been, discussed about in the press. So again, I think that you, in your decision in 2007, you properly analyzed the jurisdictional issues. You made the right decision. It is consistent with ICTA, and there is nothing in the statute that precludes your exercising jurisdiction. Now, if you were to embrace the petitioner's argument about jurisdiction, in our view, that would lead to a result that is inconsistent with congressional intent. In essence, the petitioners would have you conclude that no federal agency would oversee the construction and operation of high-speed rail lines. This result, in our view, is clearly inconsistent with the congressional intent to give this agency broad jurisdiction over rail transportation. Again, mentioning that earlier case, CSX, Georgia Public Service Commission, in which a Third Circuit case is cited, U.S. v. Bishop, the court talked about Congress's interest in regulating interstate commerce and talked about railroads being instrumentalities of interstate commerce. Congress has given this agency expansive jurisdiction over the nation's railroad network, as indicated by the words of the statute we have discussed here today and the precedent that is in the materials and that we have also discussed. High-speed rail will be part of interstate commerce. It will be part of the rail network, the instrumentality of interstate commerce. And the STB should have jurisdiction over it. I also think that the petitioners would have you decline jurisdiction because this particular type of project is not specifically spelled out in the statute as being covered. Again, I have talked about how we do not believe that the statute precludes the exercise of jurisdiction here, and that ICTA gives you the expansive jurisdiction that you can exercise in this case. But I think the petitioners are asking you to interpret the statute in a very narrow way. The STB's jurisdiction over high-speed rail is a matter of first impression. High-speed rail is a matter of first impression, and that's why we're here today. But statutes breathe. They're intended to breathe. Congress passes laws with the hope that the agencies who are instructed to implement the laws will accommodate the law to the circumstances as they change. And we view this situation as just one of those cases. It would be appropriate for this board to apply its expansive jurisdiction to the DesertXpress matter. And let me also say that there has been discussion here about who would be harmed by this decision, and I have heard that the petitioners feel that they have been disadvantaged by the 2007 decision, and I find that hard to imagine. As was stated here earlier, the petitioners, as have we, can seek your jurisdiction. They can seek whatever permissions are needed through the exercise of your jurisdiction. And this case is not about preventing them from using the jurisdiction here like anyone else. As a matter of fact, I think that if this 2007 decision were overturned, the ones disadvantaged would be DesertXpress. Because they have relied on this decision since 2007. It was an informed decision. Obviously, this board takes time to issue decisions and looks at precedents before making decisions. It was an informed decision, and DesertXpress has relied upon that decision. And in the interest of finality, particularly when the petitioners have not met the burden of reopening, the DesertXpress would be clearly disadvantaged by a reopening.
The right-of-way that DesertXpress intends to construct this line over is very, very similar to the right-of-way I think that the American Maglev wants to use, and I believe that's parallels the I-15 corridor.
Yes.
Isn't much of that land through BLM territory, and it's basically federal land,
Yes.
a lot of it, isn't it? Yeah.
Yes, that's correct.
So has DesertXpress been working with the BLM and other federal agencies in terms of the environmental impacts?
Yes, DesertXpress has been working very diligently with all of the agencies as part of the environmental review process. They have been working with BLM in particular because, as you mentioned, their land is affected, will be affected by this. And I heard the petitioner earlier indicate that the motive here is to seek preemption from state and local environmental laws, which, of course, that is the operation of the statute. But that said, DesertXpress has been meeting not only with federal agencies, but also with state and local individuals in connection with their concerns in the environmental area.
Mrs. Morgan, you mentioned that that STB jurisdiction over a high-speed rail is a case of first impression, but can you think of any other examples where a regulatory regime was put in place but then was eliminated or was rendered non-workable because the mode of transportation got more efficient over time? I'm just trying to. I understand your point, first impression in one sense, but it's not unique at all that in history of transportation that regulated modes of transportation have matured and developed efficiencies, and in fact, I think every single mode one could think about has accomplished that. It may arguably it's taken the railroad industry a little longer than some others in recent decades to make that leap, but what would be the argument for a system of economic regulation and regulation of construction and preemption to be superseded just by efficiencies being realized and improved technology?
Well, I think if you look at the history of this agency and the precedent, you will see evolutions on many issues, which I think speaks to the fact that Congress passes a law and then creates an agency that then has the authority to alter the implementation of the law to reflect the changing circumstances. I mean, efficiencies are going on all the time in transportation and in rail transportation. So if you look at the specifics of the statute, transactions, exemptions from the statute to accommodate efficiencies in the transportation network, that's what this board has been about, and the ICC before it. When you started to ask me the question, the immediate example that came to my mind, and when I speak it, people will know why it would immediately come to my mind, was when we were involved in many mergers in the freight rail industry, and we got to a point where the existing regulatory administrative regime was not reflecting the circumstance in the marketplace, that we were now coming to a critical point with respect to more mergers. And so this body issued a moratorium and then issued a set of new regulations. And that's a good example of you reach a point where what has been in place no longer reflects the circumstance that this agency is faced with. But that does not mean that you do not have jurisdiction to deal with it. It just means that you alter how you approach it. And I would say also on that point that the petitioner indicated that high-speed rail would not fit into the regulatory framework that now exists with respect to freight railroads. And all I would say on that is that, well, this body has exemptions where a part of something is regulated and the other part is not. And even if you're not regulating it, you still have jurisdiction over it. So there are a lot of ways that you could responsibly exercise your jurisdiction in this area. If
I could follow up on that, are you aware of any statutory definition of high-speed rail, either in statute or regulation, of what defines it?
I don't know that. I mean, I would have to, double check that, because it may be, and I just don't recall it right now. But I don't remember that there was a specific definition of high-speed rail. I think there is a lot of conversation about levels of high-speed rail and when is something super high speed and so forth.
That's my understanding. In fact, I've read in a reputable journal recently remarks of the Federal Railroad Administrator to the effect that high-speed rail may mean one thing in one market, perhaps taking 50-mile-an-hour passenger rail up to 90 or 110 would qualify for some of the new federal money that FRA is administering. In another market, it could be even a faster level of service, depending on track conditions and distances between stations and what have you. So I believe there is no set definition. It's just passenger rail a little faster, maybe a lot faster. If I could ask you a follow-up question. You've had a distinguished career as a congressional staffer and elsewhere. If this was an error, the statutory reference to the movement of passengers being part of the definition of transportation, which is built into the applicable law here, wouldn't in your opinion, the California and Nevada congressional delegations be well situated to correct that? And aren't there proposed, or at least discussions of proposed vehicles, legislative vehicles that might be moving in the near future in Congress that would be perfectly a natural opportunity to correct such a mistake if in fact that was a mistake?
You mean a mistake being that passenger was not?
A mistake, yes.
Yeah, well,
clearly in the statute. So the question is, do we ignore it or deem it some kind of error, or perhaps agree with Mr. Von Eigen's assertion that what it really means is only freight, interstate transportation. But Congress has and particularly the Nevada and California delegations, and I think about who was on those delegations and their leadership roles, they have every ability to correct such a situation if they thought it was interfering with the interests of either of those states.
They certainly do have that ability, sure.
There's high-speed rail and there's highest speed rail, and it is a difficult one. And I want to ask you, we're dealing here with two different technologies. The Desert Express is conventional steel rail technology, similar to what is used in Europe with the TGV and others, whereas maglev is a whole new technology, but it's also been classified as a railroad. The American Magline and the Maglev Commission suggests that Desert Express is a high-speed rail not connected to the national network and therefore should not be under our jurisdiction. On the other hand, you've argued that it is part of the national network or could be part of the national network and it should be part of the jurisdiction. Wouldn't the same arguments that would apply to, however we decide, wouldn't the same conclusion that we reach with regard to Desert Express also apply with the same force to a maglev system? Since even though the technologies are different, the classification of it as a railroad puts it under the most of the railroad rules and regulations from FRA and FELA and railroad retirement and RLA and the like.
And, well, that's my position. That's our position, and we
so
reflect that
maglev
in the
should also be coming to us for authority to build its operation between Anaheim and Las Vegas, just as you are between Victorville and Las Vegas, correct?
My position is that they've you know, as I said earlier, they feel disadvantaged, that somehow we're getting some advantage by coming here that they can't have, and I don't see that disadvantage. They can come here and pursue it as they wish.
If they had started to actually begin constructing this line, do you think that Desert Express might have come before the board asking us to intervene and to say, hey, you've got to come before us? That's speculative, of course, but but you feel strongly that this is certainly something that we should be authorizing.
I think I think the way that I would answer that is to say that Desert Express has been proceeding to get its own project in order. It has spent a tremendous amount of time working through issues, working at the state and local level, and coming here for guidance. That's what the 2000 decision was all about, is coming here to make sure that we were proceeding appropriately and legally. So this has been about Desert Express and Desert Express proceeding ahead responsibly and legally. Whatever maglev is doing, they're doing.
Thank you. Mrs. Morgan, if we decided that we wanted to clarify that this agency does have jurisdiction over magnetic levitation transportation along corridors that look like rail corridors and in vehicles that look like trains, and a much more natural fit in view of the existing FRA regulatory jurisdiction that the maglev party here concedes. Wouldn't be the case that someone such as American Maglev would have the opportunity to avail themselves of the federal preemption, but at the same time could make a business or strategic or community affairs or community relations based decision not to avail themselves of that. They may want to win the Sacramento Citizen of the Year award or whatever other or seek have a better chance of getting state funding perhaps if they earned the goodwill of state officials by not availing themselves even though they had the authority to. Is that a fair statement? Did I get that correct in your view? Or okay.
Yes.
So it's not mandatory. In other words, they don't, just because they have the availability of preemption, they're not required to ignore state agencies or. And
I think for all of us who have worked in around these issues understand that the preemption exists with respect to the environmental laws. However, there is a tremendous amount of cooperative effort that goes into preparing an environmental document for final approval and with this agency and other agencies. So.
Now, turning to sort of the business dynamics at work here, this is a very competitive situation. There is significant federal money that's been made available. There's some state money that's been made available, particularly in California. There's private money that's possibly being looked at, and it's competitive all the way around, right? You're not just competing with a maglev proposal. You're competing with the LA to Sacramento line or the Chicago to St. Louis line that's proposed, the Orlando to Tampa. I mean, there are some 40 plus, if I read the press correctly, applications that have come in for a piece of this $8 to $11 billion, depending how it's added up. And it's extremely competitive all the way around. And do you view that we've done anything that's put any particular project at a competitive advantage or disadvantage that's going to actually alter which those projects get selected for federal and state funding?
No, I don't believe so. DesertXpress is not pursuing any stimulus money. As you know, they have invested a lot of their own private capital, and they continue to look for private capital in the marketplace as this project proceeds ahead. So they are not looking for grants or any stimulus money. But I think that if this agency has jurisdiction, it should exercise it, and the funding issues will get resolved on another path.
Thank you. I have no further questions, Mr. Chairman.
Well done.
That's all I have. Thank you.
Thank you. Mr. Edelman, you have 10 minutes.
Thank you. Good afternoon, Chairman Elliott, Vice Chairman Nottingham, Commissioner Mulvey. I'm Richard Edelman. I'm here on behalf of the IBT Rail Conference and its affiliates, the Brotherhood of Maintenance Way Employees Division and the Brotherhood of Locomotive Engineers and Trainmen. I represent other rail unions, and they have not joined this case because those other unions were not parties to this case like it started, just like the putative interveners. They weren't parties. Those other unions aren't here. They shouldn't be here either. The rail conference unions represent maintenance of way employees and engineers and trainmen on the major railroads. They have a strong interest in protecting standard wages, benefits, and rights of railroad workers and ensuring that entities that are involved in railroad operations are properly classified as carriers under the Interstate Commerce Act. This is because most of the laws that apply to railroad workers, like the Railway Labor Act, the Railroad Retirement Act, depend on the ICA definition of carrier. If an entity is not a carrier under the ICA, it is not a carrier under those laws, and its employees are not covered by those laws. If a several hundred-mile line is not classified as a carrier, then several hundred people who work on that line are not covered by the railroad laws covering employees, even though they're doing railroad work. Now, you've heard putative interveners earlier say that they think they're a railroad under the FRA, but not under the ICA. Well, in that scenario, their employees doing railroad work, building this railroad, operating this railroad, would not be covered by the Railway Labor Act and Railroad Retirement Act.
Is that your understanding that they are not? Because it was my understanding that Maglev, because it was declared to be a railroad, that Maglev would operate under the Railway Labor Act, under the FILA, and under railroad retirement.
If they're taking the position that they are not covered by the ICA, then they're taking the position they are not covered by the Railway Labor Act and Railroad Retirement Act. If they want to clarify that and say they are, I'm glad to hear it, but I don't think that's what they've said. And if you look at the statutory definitions in the RLA and the ICA, they refer to this statute. Now, additionally, rail workers have been victimized by sham transactions and finagling to get out of STB regulation for a long time. And we have an interest in making sure that that doesn't happen. We have an interest in making sure that parties don't manipulate or evade STB jurisdiction. Those are our interests, specific to us. We agree with DesertXpress that the putative intervention and petition to reopen 2 years after the decision was rendered for the purpose of challenging the carrier status of somebody else is grossly improper, and the petition should be rejected on that basis. And the supposed excuses they've offered are frankly frivolous. The putative interveners made a calculated business decision not to get involved in this when they knew it was going on. They made a calculated business decision not to get involved with this when, a week after the decision came out, they were formally notified and they didn't seek to reopen back then. Now they've made a calculated business decision to do something else, to get themselves involved and take a different position. But this is really, they call this about jurisdiction, this is really a change in their assessment of the competitive environment, whatever it is. And I would point out that the rail conference and 2 transit agencies in New Jersey felt it was in their interest to participate in this proceeding when it was ongoing. They knew it was ongoing. The New Jersey guys, they felt that they weren't even involved in this. They got themselves involved. So I would also note unions regularly participate in proceedings before this board to protect their members' interests. Sometimes we have to decide, are we going to get involved? When do we get involved? The petition here is as if someone sought authority to buy a railway line under 10901, went through the process, no union opposed, got a decision, the board approved the sale, and then later, when we found out that they weren't going to hire any of our people, we said, oh, hey, wait a minute, we want to get involved now, reopen it, it's really a 11323 transaction. Or, you know, maybe we thought Congress was going to get involved, and then they didn't. We came in. We would be time barred. They should be time barred. On the merits, we agree with DesertXpress that it will be a rail carrier. We want to respond to several different points. Again, and I think as you've heard, Commissioner Mulvey, you mentioned the exception for interurban, electric railways is about, as you pointed out, close things within cities. This is interstate. You can call it interurban. I mean, hell, you could say that something running between New York and Chicago is between two cities. It doesn't mean it's interurban within the meaning of this statute. In essence, they're saying that DesertXpress is going to be a several hundred-mile long interstate trolley or subway. That's just ridiculous. The Staten Island Railway decision on which they've relied is irrelevant because there was a line. The line was entirely intrastate and owned by the city of New York. Its connection to the interstate system was relevant because that's where there was the interstate connection. Otherwise, the rest of it was intrastate. So it was a carrier as long as that went on. Once the interstate movements stopped and that ceased, then they were only an intrastate operation. That decision provides no support for the position they want to take here. Similarly, the Sprague case, which I was handed just before we got here, and I'm taking a little liberty with the advice to turn off the phones. I did check Google. All of the cities that are listed there are in the state of Illinois. The key to that decision where they refer to interstate movements and connection was important because otherwise it was entirely intrastate. DesertXpress is interstate. And we cited to you the Fox case, and the reason we did is they're an intrastate yard track disconnected from the interstate system by removal of a switch was held still to be within the board's jurisdiction. And among other things, the board said, well, they might sell the track to somebody else, and that the switch could be restored. So here, if an intrastate yard track that has been disconnected from the interstate system but could be reattached is within the board's jurisdiction, then we think clearly an interstate line must be within the board's jurisdiction. I would also just like to point out, I kept hearing some phrase like the interstate general freight system. You notice that doesn't appear in the statute. Now, the absurdity of the position that's being advocated by putative interveners is demonstrated by, let's think about some situations, some of which I think the board members have alluded to already. Suppose the LA to Las Vegas line was extended to Phoenix, and then to Albuquerque, and then to Denver. There would be common carrier passenger service across 4 states, but under their theory, it wouldn't be a rail carrier under the Act. Well, then who would regulate it? Would each state? Would they have a different type of regulation? I mean, as Vice Chairman Nottingham noted, that would happen. And that sounds exactly like what they had in the early 1800s, which was why the Interstate Commerce Act was passed, where states were played off against one another, or they had a conflicting set of regulations. It was the very reason why this statute, its originator, was put into place. Or maybe they want no regulation at all. They're sui generis. They're magnetic. So there's no regulation at all. It takes us back to the early 1800s. And that's sort of what I thought I heard earlier. And well, what's wrong with the states doing this? Well, I think the history is that was a problem. That was a problem. Well, take another scenario. Suppose there's a Los Angeles to Las Vegas line, and then someone else makes another passenger-only line that doesn't connect with the freight line from Phoenix to Las Vegas, but it terminates on the east side of the city. And then someone else builds a Denver to Albuquerque line, then somebody else wants to go from Phoenix to Albuquerque. Well, that's the sort of patchwork, inefficient, non-integrated system in World War I that led to amendment of the Act after World War I. Again, and Vice Chairman Nottingham, you referred to the board's interest in helping the efficiency and effectiveness of rail operations. That's part of the history of this Act. And I think, somehow I've sort of got this notion that, fundamentally they've got a new technology, so that doesn't integrate. So its competitors should be excluded too. Well, that's not a basis for the board to make this decision. And I think that it occurred to me as I heard some of the questions, when railroads went from steam to diesel, nobody said the ICC doesn't have any jurisdiction anymore. And when you talk about electric, on the Northeast Corridor, there's overhead catenary lines to provide electric power. It didn't make them not a railroad. So I think that those are specious distinctions. Just one last thing, and I've alluded to this in my brief, to the extent that they rely on the state of Maine line of decisions. I think, one, they're distinguishable primarily because all of those were intrastate. Two, we respectfully submit those decisions were wrongly decided. We've challenged that doctrine elsewhere, and all I want to say at this point is to say that we think they were wrong then. There's no such concept as an operating easement. They shouldn't be perpetuated, but they certainly shouldn't be extended. If there's no questions, I'll be glad to sit down. I'll be glad to any questions you would like me to answer.
Thank you, Mr. Edelman.
Thank you.
I'll deal with those cases later. Rebuttal?
Yes. First, I want to say that once again, we're not here to avoid labor, the coverage of the Railway Labor Act. We're here to make the point that the Congress did not contemplate a separate passenger-only rail network being subject to the jurisdiction of the
With respect
board.
to Mr. Edelman's point, is it your position, if the board so rules in your favor, that you're, hypothetically, if the maglev goes forward, your employees would not be covered under the Railway Labor Act or retirement FILA,
I
et cetera?
believe it does only apply to rail carriers under the Interstate Commerce Act. I think he's right about that. That's not the motive, but that would be an effect of it, and it would be subject to the National Labor Relations Act, or if they're public agencies like the transit authorities, they would be regulated at the state level in different ways as public employees. But that's not what we're talking about here. We're saying that here there is no jurisdiction.
But some of the public transit employees, for example, those who work for the PATH, are considered to be railway employees, and PATH workers are subject to RLA and some of the other. Is that correct?
That's true, and those are many over the freight rail network. That would be often the case. In fact, I represent Metra, and that is the case with Metra.
But they're no longer. But in the case of PATH, they're no longer over the freight rail network. They're now separate from the freight rail network, but they're still on the RLA. And it is not determined. I mean, my understanding is that that was not decided, but one of the issues that was considered when maglev was declared to be a railway, one of the issues was that because it's a railway, it was going to be under the some of the things that govern railroads, not because the Federal Employees Liability Act is an act separate from the Interstate Commerce Act and the Railway Labor Act and the others. So it's hardly a matter of settled law that they would not be under these requirements. No.
I'm not familiar with the issue. It's not our point of view here. I really can't tell you that. But my understanding is that the Railway Labor Act is triggered by being a rail carrier under the Interstate Commerce Act. So I think in that case, Mr. Edelman's correct. The point I do want to make, though, is that, first of all, this notion that the board should fill this gap on its own. It's one thing to stop a rail merger guidelines that were set out by the board in implementing a specific area of jurisdiction that this board has to look over control cases and consolidations of railroads to say, hey, we had a couple of disasters. Let's take a look at them before we approve any others. that's an evolution that should occur, and that's certainly part of the board's discretion to change its policies. But
what about to Mr. Edelman's point about if this did run from, hypothetically, from Los Angeles to St. Louis and went through various states, that each different state would be regulating it in your scenario? Would that be workable?
I think it's absolutely workable. We've seen it in California and Nevada, where the local communities are very supportive of getting this service. The cities that have endorsed it are opening their arms to this kind of service. They want to see this happen. I don't think it's a foregone conclusion we're going to have problems here. If there is, then we can come back and face them and get Congress to enact the laws necessary and the instructions for you how to resolve these questions. My concern is that you declare the preemption under 501B as being broad, and that was the whole purpose of the original decision. It wasn't. They didn't come. DesertXpress didn't come in and ask whether or not a rail entity that does not provide shipper service, that is not connected to the freight rail network, is part of the rail network. That wasn't the questions that were asked. The question is, how broad is 10501B 1 and 2? That wasn't even a controversial issue at that time, but that's the question they asked, and the board presumptively assumed that the other issues have been taken care of. And I just don't think that I don't think Vice Chairman Nottingham, I don't think the words transportation are a mistake in the Act. It's part of the definition of the board's jurisdiction. It certainly applies in the context of passenger service on freight right-of-way, which is the predominant model we have today, and it gives you jurisdiction in that context.
But with all due respect, Mr. Van Hagen, it does not say freight rail transportation. It just says related to the movement of passengers or property or both by rail. I
understand that, but I think that the 10501, going back to what does give you jurisdiction, is 10501A2A, and it says you have to be part of the interstate rail network. And what I'm saying is that a disconnected passenger-only railroad is not part of that network because it does not connect. And it does not interchange freight, which is there's numerous decisions cited in our cases that do hold that unless, even in the cases where there is connections between entities that provide passenger service and the freight rail network, that unless they engage in the transfer of that, it's not part of the jurisdiction of the old ICC or the STB.
Going back to my earlier question, isn't it at best that ambiguous?
Is what ambiguous?
With respect to whether or not it's covered under the passenger has to be on the freight transportation system, the language that you're referring to?
I think there's no controversy about the board's jurisdiction over passengers on the interstate rail network. I think the definition of rail carrier requires you to make a finding as to whether or not the service provided by DesertXpress, in fact, is part of that network. And I don't think you made that decision and even looked at the issue in the June 27, 2007 decision. I think the connectivity to the rail network in the trails cases that were cited by DesertXpress are supportive of our position. So that's all.
Mr. Van Hagen, turning to the some of the operational realities of maglev, is there a kind of an optimal distance between stops to achieve the most efficient transportation? For example, if you had a 200-mile corridor, would you want to stop 20 times, 10 times between 4 and 7? These are the issues that, of course, historically have led to federal preemption, because states find it very difficult to tell localities within their state that they're just not going to get the stop. And everybody wants a stop, presumably, on a high-quality transportation mode. But to keep it high quality and fast, by definition, not everyone can get a stop. And isn't it completely predictable that a improved national system of higher speed rail and or maglev rail cannot work if each and every state gets to stop it, alter it, and regulate it?
Well, I think it's certainly something that could be regulated at the state level as well as at the federal level. I think we as a carrier a railroad carrier could make the point that would be inefficient for us to stop. Now, we were talking about 7 stops along the right-of-way between Anaheim and Las Vegas, and we think that's optimal. We have the support of the communities that will be served by it. We have not been pelted with proposals to have other stops.
And when would your line be up and running according to your current plans?
Well, there is a petition in our case before the Federal Railroad Administration. It was submitted by the governor of Nevada and Nevada DOT to fund the PRIM to a Las Vegas segment, and then to also fund also to fund the engineering for the California portion of the route between Anaheim and Barstow. So that would be.
And that would be over what time period? Assuming you got whatever funding you needed to get.
The studies, would be the final environmental project impact statements would be done, and the engineering would be done, and then we would go to financing at the conclusion of that.
We're talking about 3 years, 7 years, 9 years, 20 years. When do you anticipate, if you get the funding you need, when you need it, that you'll have people experiencing maglev between that corridor between Anaheim and Las Vegas?
Well, I think the development of many of these systems are going to be take longer than people would want, but I think in this particular case that if these environmental processes could be completed in 2 years or 3 years, then the construction could begin at that point. And there would be service over both segments of the system, and then the final link would be the link between Prim and Barstow.
Any further questions?
No further questions.
Thank you.
Thank you very much for all your excellent arguments and for your attendance today. And our next oral argument will be on November 23rd, 2009, barring any unforeseen circumstances. And yeah, hopefully in the morning. And now this meeting of the board is now adjourned. Thank you.